Hello, hi. Okay, I just want to. Today is the first episode on Malaysian law. Um, okay, if you look at this particular case, Marsiling Properties loses appeal, ordered to pay 322,000 damages. This is called LAD damages, liquidated, late delivery liquidated damages. Basically, this is actually it's like someone buys a property, and then the developer or the seller has X amount of time to complete the property. Usually, it's 24 months, 36 months, or 48 months. So, in the sale and purchase agreement, usually there will be a clause that says that this stipulated timeline. You can look for that particular clause. It will be under the subheader manner of time for delivery of vacant possession, and there will be another clause that says manner of delivery of vacant possession. The manner of delivery of vacant possession means that usually how do you define a property is completed from the seller's part, whereby property is transferred, is ready, able, and to transfer to the purchaser. So the manner usually the developer will be, of course, you need to get the roof done, the structure all completed, and the structural integrity of the building intact. And then, of course, the seller has to energize the property with electricity, water supply, indoor water supply as well, ready for connection, meaning ready for that. That's a word that in legal terms called legal ready for connection, which actually means that it's ready for the buyer to apply to indoor water connect DNB and Wi-Fi and all to connect water. So these are court of appeal cases. I believe there was already a high court matter. That's why, the high court matter probably Marsiling lost the first round, and this is a second round battle. If you look at it, it's a court of appeal over three panel of judges. So as you can see, court of appeal, three members upheld the decision of the Kuala Lumpur High Court and also Sessions Court. So this is the third round. So it was a unanimous decision. Um, by all three different judges. So they ordered that the Marsiling to pay costs as well, which is in addition to the computation of the late payment interest. So let's discuss generally how we compute this 322,000. Okay, basically, when is time start to run and when time stops, where that's where there'll be the time when you calculate. So I just give you an example of, let's say, 100,000, and a property that you buy, and assuming that the property is supposed to be delivered within 24 months. But of course, due to some circumstances, the property was there was a delay on the seller's part, developer's part to deliver the property. So the property was finally handed over in year three, 36 months. Okay, that's for purpose of easy discussion. So there was a delay of a year. So if 100,000, usually the clause for late payment interest will be ranging from 6% to 12%. But if you look at sale and purchase agreement, usually for under construction property, is usually at 10. So 100,000 means there'll be 10,000 per year, 10,000 estimated per year to be paid. So if you look at there's a 1 year delay, so basically you will need to pay. There'll be that means there's a delay of 365 days, which is 1 year. So if you average 100,000, so what you do is you get um, the 10,000 out per day, the 10,000 per year. And of course, in this case, you don't have to calculate the per day charges because we are talking about delay of the 365 days. So it will be 10,000 that is payable by the seller to the buyer. So when the seller have to pay this to the buyer, they have to pay during the handover of keys period, and not later. But if let's say the delay is 200 days, then what you need to do is you need to get 10,000 ringgit divided by 365 days. So you get per day charges. Then you multiply by 200 days or 100 days delay. That's how you compute. So take note, sometimes developer, seller, they will use unscrupulous ways to try to uh, produce those certificates. Usually, if you talk about like TMB, electricity connection that is ready for the buyer to just apply, they usually will need to get the architect to apply for a certificate to say that the electricity cabling has already been connected up to the building or to the said parcel, which is the apartments. But sometimes you get a temporary connection permit. So this may not be good enough. And of course, the seller will try to use those certificates to say that, oh, yeah, vacant possession has already been delivered. So time already should stop running. So, but some buyer who are more intelligent and more, they will try to stretch, say that this is not actually the proper handover. So there's we will still have to wait for the final for certificate for the electricity connection to get. So the seller may need another 100 days. So the 200 days delay, you have to add another 100 days. So time will stop running in terms of the calculation. So at the end of the day, instead of 200 days delay, you'll be 300 days delay. So if you can see, they enter into a purchase of a detached factory. It's like a bungalow factory in Johor. So they are supposed to deliver vacant possession within 36 months of the SPA, but failed to deliver on time. So the purchaser, Xingda, filed a writ of summons in Sessions Court first, a claim of LAD for late delivery of the said property. Of course, here they got extension of time. Of course, if sellers, sometimes they will try to get the engineer who was supposed to be independent, to say that there was unforeseen circumstances. It could be bencana alam or earthquake, heavy rain, or unusual weather. But usually these are not really provided for. It's not really an excuse for the seller to get an extension, because everyone have their own problems. The buyer will have to find money to pay up. The buyer may have their own individual problems of finding the money to pay up to the seller, and then the seller would have obstacles along the way to complete building the property. So this is like part and parcel of performance of parties, of the responsibility and the burden of parties, two parties who contract to buy and to sell their own problems. So you can't really actually push the problem to say that, oh, because of this personal problem that I have, or lack of staff, labor issue, I want to get an extension of time so that my original agreed 36 months, I want to get an additional extension of time without interest for another 1 year. So the court actually rejected this. So this is actually a good precedent for new cases, for new disputes. It's like it's like a bit of a landmark because this is considered court of appeal matter. So claim that on the other hand, Zingda claimed that in order for Marsin property to entitle for EOT, the company must prove clause 20.1 that the architect have formed an opinion there was a force majeure event before it can claim for any EOT. Okay, this is what I'm trying to get to. You see, everyone will have their own situation or obstacles while trying to complete a project or trying to perform something during a contract. Like for example, if it's a buyer, to make payment, if it's a seller, to complete the property. Okay, but there are situations whereby it's outside the control of the two parties, which in this case called a force majeure event crops up, which is, let's say, an earthquake causes the whole building to be, which is under construction, to be that needs to be demolished, or there are something breaks because of the earthquake. So some important structure like a column. So that's why resulting in which is not Marcin's fault, which is they are actually on time, they're building everything, but some serious matter outside the control of the party. So if they can prove that it's under 20, so basically architects or engineers, they are usually called the independent persons that help to mediate any dispute between a buyer and a seller. They will have to come to this conclusion first, not just simple bad weather, So yeah, so trying to keep my video all at 10 minutes. I will stop here, which is I think I will continue in my next video. So basically the 322,000 is payable, cost of 13,000, and there's an interest to be paid as well from the date of the filing of the writ until full settlement. So if the court case from sessions court to high court to court of appeal takes another 2 years, so there will be another how to say 5% interest on the 322,000, which I would say comes from about 16,000 a year, another 32,000. So that's all for today. Thank you very much.